Mr. Buller.
May it please the court. Good afternoon, your honors. Both the facts and the law support the admission of the medical examiner's opinions as to cause and manner of death in this case. Where I want to start off is clearing up what may be a misconception about the record. Dr. Thompson's opinions in this case were not solely based on the defendant's statements. There's at least 4 independent pieces of physical evidence that he relied on. We have the medical examination of the body, we have x-rays, we have a blood and organ analysis including toxicology, and we have photographs of the scene. From this evidence, Dr. Thompson ruled out bacterial and viral infections. He ruled out disorders related to metabolism, he ruled out blunt force trauma, and he ruled out drug and alcohol abuse.
Why shouldn't his opinion have stopped right there?
Because there's additional evidence that is consistent with the defendant's statements here. We have the partially expanded alveoli, and we have fluid found in baby Tyler's tracheobronchial tree. That evidence supports the defendant's statements. And the defendant's argument on appeal is really based on this faulty premise that a medical examiner's job doesn't have anything to do with witness statements, and that's simply not true. The medical examiner's amicus brief here is very clear. All physicians rely on patient history when forming medical opinions, and medical examiners aren't any exception to that. But there is a difference, of course. Instead of asking a living patient what happened and how did you get hurt, the dead can't speak for themselves, so medical examiners have to look to the next best source. That's often going to be an eyewitness, and in this case...
But there has to be some medical indication, whether it's subjective or objective, to support their opinion that drowning, that this woman caused the drowning. And the problem is that if you don't have that independent medical you can't get subjective because the baby can't talk. So you got to go by any objective symptoms. And if you don't have any of these objective symptoms, all you're doing is having the medical examiner say, this person said it, so it has to be true. And that's the problem. And anywhere you have medical testimony, so you need to tell me or tell this court what medical objective symptoms were consistent with drowning in this autopsy. Now, I know there were things that didn't happen, but that doesn't mean a million other things could happen. Just because the ground's wet doesn't mean it rained. It could be a sprinkler. So you tell me what symptoms objectively that this doctor can rely on to get to his opinions.
There are 2 pieces we start with, and that's the fluid found in the tracheobronchial tree, and then there's the partially expanded lung alveoli. What's important to remember is that medicine isn't a 100% certainty science. There's no magic test to determine certain conditions. If you think about something like back pain, if you walk into the doctor's office with back pain, there's no blood analysis where that's going to show up. It may not even show up on an x-ray. So what the doctor will do is certain tests to rule out alternative diagnoses, and then he'll ask the patient, what happened and how did you get hurt? If I walk into the doctor's office with wrist pain and I tell the doctor I got hit with a baseball bat in the wrist, there's no question the doctor can rely on my statement to form an opinion about the source of injury, even if there isn't objective evidence that a baseball bat is what caused that injury.
But in this case, both of those independent medical things that you talked about, he couldn't state that to a reasonable degree of medical certainty because he had on cross-examination, of course, he had an explanation that he couldn't determine that the fluid found in the trachea or in the lungs at that time wasn't just amniotic fluid. And so he couldn't rule that out. He couldn't say that it's bath water. And then under the partial lung, he said that could have been caused by any number of things, including just the buildup of methane gas after the death of the child, unfortunately, by whatever means. And so other than that, what else is there in the record that would support his conclusion about this?
If we pluck out individual pieces of evidence, they aren't going to tell the whole story. That's what Dr. Thompson was testifying to on cross. If you have this entire puzzle and you just look at one piece, you're not going to be able to figure out what the puzzle is.
It's up to the jury to determine whether or not the fact issue. Was this child dead before or after in the bathroom? That's the fact question. Now, you have the confession, which got into evidence. You have this conflicting medical testimony, and I have no problem with the doctor testifying. In my opinion, none of this happened, and in my opinion, there was water in the esophagus, but I don't know where it came from, and it could have been either one. In my opinion, I don't know what caused the other thing, and let the jury make the final connecting the dots. That's the problem, because he seems to be vouching her credibility in confessing, and that's the problem. Now, if there was water in the lungs that was consistent with bath water or any other thing like that, it's a different story to me. But, do you understand what I'm trying to get at?
I do, Your Honor, and there are a couple pieces in there I want to address. The first is your vouching comment. I don't think there is any evidence in this record that at trial, Dr. Thompson vouched for anyone. He didn't talk about believability. He didn't talk about credibility. He didn't say that he believed the defendant's confession. The only place any of those statements were made was pre-trial in a deposition. The Court of Appeals relied on that deposition to kind of hang Dr. Thompson at trial, and the state's position is that was not an appropriate use of that evidence. We're looking at the evidence that was offered at trial by Dr. Thompson, and he didn't vouch under Myers or any other of this court's decisions.
When he says she died by drowning, he's vouching for her version. I mean, we don't want to need to play games. That's what he's saying, because he has no other reason to say she died by the child died by drowning without that statement.
Your Honor, I don't agree with that. The doctor's opinion was to a reasonable degree of medical certainty, and he absolutely looked at medical evidence to form that opinion. He ruled out a number of causes of death, including blunt force trauma, alcohol abuse, those other things I listed off earlier, and there were independent medical bases for that diagnosis.
Sure, and I don't have any problem with any of that. But please correct me if I'm wrong here, but the impression that I have gotten from reading the briefs and looking at parts of the record at least is that although he ruled out A, B, and C, and he did scientific inquiry that is perfectly admissible, but for the statement, he would not have reached the opinion ultimately given. So so basically stripping it all away, without the statement that he's using, he's got to be believing in it to come to his opinion. Now, do I have it wrong? Am I missing it? Please help me.
Dr. Thompson did testify that without the defendant's statements, he could not have ruled this a homicide by drowning. But I don't think that's unusual in the context of a medical examiner. The Rollins case out of Maryland talks about this at great length. The ME there, just like the medical examiner's amicus brief, says that all medical examiners, indeed all physicians, have to look at a combination of physical evidence and witness statements or scene findings. The Rollins ME's position was that without scene findings, you can never come to an opinion.
But at the end of the day, he's basically saying, I believe her, that's the basis of my opinion. Is he not?
No, Your Honor, I don't agree with that. Nothing close to a credibility statement came out on this record.
But you're right in one sense. I mean, he didn't say I believe her. He didn't say I judged her credibility and I saw her demeanor, anything like that. But if you take your little magic marker and exclude her statement, he would not have been able to offer the opinion he did, I think. Now, I have no problem. I mean, if that's what would have happened at trial, which would have been helpful to the prosecution, I ruled out this, I ruled out that, I ruled out this, that would have been still very helpful, but not as helpful as what you ended up with, of course. But in fact, to go that extra step, the extra step was based solely on belief in the credibility of the statement.
I do want to push back on that, Your Honor. I think there's a difference between what the Court of Appeals calls solely relying on evidence and not being able to come to a final conclusion without the full picture. The latter example is what we have here. Even something as simple as a gunshot wound to the head can't be ruled homicide or suicide without scene findings, without this additional information, without what Dr. Thompson calls patient history. There might be some suggestion about the placement of the gunshot wound that suggests whether or not it's homicide or suicide, but that's akin to what we have here, where
in the gunshot case, you got a bullet in the head, or you got a gunshot wound, and he knew the person died by a bullet. So when you say somebody said they shot at her history, that's different. He didn't know this kid drowned without that statement. That's the difference between your two hypotheticals.
I don't think they are different, Your Honor. The testimony we have in this record, including from the defendant's own expert, is that there is no unequivocal test to determine drowning. And this is true in all areas of medicine. There isn't a test for every kind of diagnosis you might get. The job of a physician is to rule out certain diagnoses and then find the one that is the most medically likely. That's what Dr. Thompson did here. The defense expert identified some common post-mortem findings, like the water in the tracheobronchial tree and the fluid found inside the lungs, and those were present here. With the addition of the scene findings and with the addition of the patient history, the medical examiner properly concluded, under his duty under the Iowa Code, that this was a homicide and the mechanism of death was drowning.
Realize we're focusing on medical examiners, but don't in Iowa courts experts routinely, as part of their analysis and the grounds for their opinion, rely on witness statements? If we hold this as improper, does that mean that an accident reconstructionist should be barred from giving an opinion that relies on the defendant's admission or the plaintiff's admission?
Justice Waterman, that's a great question. I think the bigger problem with the rule that's put forward by the defendant isn't going to be its impact on the state. Sure, we're going to see problems in medical examiner cases in this narrow band of testimony. But every day, defendants in criminal trials call experts that can't do their jobs without relying on patient history. Think of a forensic psychologist or a forensic psychiatrist. A criminal defendant wants to put on an insanity defense under the Monotony rule or a diminished capacity defense. In order to form an opinion as to insanity, a forensic psychiatrist has to base his or her opinions on witness statements. In fact, that's basically all those opinions are based on. And in those cases, they come a lot closer to a credibility finding than we have here.
They do MMPIs, they do all kinds of psychological tests. Psychological testing. They do all kinds of things before they get to the position that it is or they do not know the right from wrong. An accident reconstructionist doesn't just come to the thing that, well, I talked to everybody and this is the accident. What they do is they measure the scenes, they measure the skid marks. They have computer programs and they have all these fancy programs on physics and stuff that tell you speed and stuff like that. I mean, all those people have some basis in their field of specialty before they give the opinion. And that's the difference. I see that as a difference here, and I guess you don't see it, and I guess it's not your job to argue that I'm right and you're wrong.
The premise that I walk away from your question, Justice Wiggins, is that there are scientific tests involved before they get to the consideration of witness statements. I think that's true with your example of the MMPI by a psychologist or certain speed tests by an accident reconstructionist. We have that in this case. We have the doctor doing everything he's supposed to do. He examined the body. He did x-rays. He did a tox screen. He did a blood and organ analysis. And from that evidence, he made scientific conclusions, ruling out numerous alternative causes of death. And that's how this part of the science works.
Once again, I'm sorry, I'm coming back to a theme, but the business of ruling out other causes, I got no problem with that coming in. That's scientifically based. It's based on his years of experience. It's his expertise. In it comes, and so he can rule out blunt force trauma, blah blah blah, and that is helping the prosecution prove its case. But you didn't stop there. Now, supposing this, I would change hypothetical to make my point, I guess, but supposing the expert said, I can't make a determination on this issue of drowning, except for what she says, and that was her testimony, would that come in? No, I take it. I mean, argue with me, if you will. And isn't that really what we have here at the end of the day?
No, Your Honor, I don't think we do. We still have a scientific opinion. All of the evidence presented in the briefs, all of the legal arguments, certainly the medical examiner's amicus brief makes very clear that part of the science of forensic pathology is considering patient history. It's just like walking into any doctor's office. Patient history is crucial, to use Dr. Thompson's
language. But look how different this is from a psychological profile, for example, and you're looking at objective patient history to make a diagnosis of some kind. And DSM-6 or whatever we have now, and we're looking at the criteria and lining all the stuff up. You know, that's one thing. But here, what we just have, it seems to me, is a statement from the accused, not some elaborate history used to make some kind of diagnosis. Oh, that's an adjustment disorder because he's had 5 of these, check. Isn't that different?
Mr. Chief Justice, I see my time's expired, if I might answer. I think the forensic psychologist example comes a lot closer to the Myers problem than we have here, and here's why. In order to diagnose someone under the DSM-5 or any other version of the DSM, you have to determine that the patient isn't malingering, that they aren't faking it. That's a lot closer to a credibility finding than anything Dr. Thompson did here. That's a psychologist saying, I believe or I don't believe this particular patient. Dr. Thompson's testimony was properly limited to the medical science.
Thank you, Counsel. Ms. Ruhtenberg.
Thank you. May it please the court, counsel. My name is Maria Ruhtenberg. I represent Hillary Tyler today, and I'm asking this court to affirm the Court of Appeals, which reversed her conviction. This is not the end of days for medical examiners. The medical examiners have a pretty broad role in investigating deaths. Their job is not just to do an autopsy report in murder cases. They rely on many different things. However, when it comes to a conclusion on an opinion of the cause and manner of death, that must be admissible. The code allows the medical examiner to do an investigation and interview witnesses. However, the code does not, or specifically states that witness statements are not admissible in the autopsy report. The opinion.
Wait a minute. Looking at 5703, Rule 5703, it says the facts or data in the particular case upon which an expert bases an opinion. This person's an expert, right? We agree on that.
Yes.
Okay. Maybe those perceived by or made known to the expert at or before the trial or hearing, if of a type reasonably relied upon by experts in the field, and we're hearing, at least in the amicus brief, that this is the kind of thing they rely on, informing opinions or inferences upon the subject, the facts or data need not be admissible in evidence. Why doesn't that rule apply?
I think the rule applies in general, but in this case, because the medical examiner's opinion was vouching for the credibility of the statements of the defendant, that makes it inadmissible under...
But how is it vouching? I mean, in cross-examination, the expert admitted, yeah, I'm getting to this point based on the statements.
It's vouching for the credibility of the witness because without her statements, there is no opinion. And so, therefore, they must be true.
Let me give you another example. Suppose this is a workers' compensation case, and we have a report from a physician stating, I believe that the claimant was injured on this, suffered a back injury on this or this date, and is now disabled by reason of that back injury that she suffered at work. Now, part of what goes into that are statements that the claimant made to the physician. What's wrong with that?
It's different in this case from statements that a patient makes to a doctor. The medical examiners are not trying to cure or treat the patient. Statements that a person makes to a doctor, even if lying, if a mother brings a child into the doctor and says this child fell down the stairs when actually she threw it against the wall, the physician doesn't have to believe her statements in order to treat that child. In a medical examiner situation, the medical examiner is preparing a forensic report. And in this case, when that is the only basis for the conclusion of homicide and drowning, and the only source of that opinion is statements that she made, and I might add, in her confession, she originally stated the baby didn't move and the baby didn't cry. Even later in the confession, when she admitted that he did, then she also says, well, he didn't really move. He wasn't moving. So the medical examiner in this case was only believing part of her statement, and there's no indication as to why he believes part of her statement and not the other part
Well,
of
why
her
doesn't
statement.
cross-examination take care of this? I mean, an effective lawyer can say, well, I looked at your report and so on, and doesn't your opinion turn solely on believing certain statement? Isn't that true? And isn't it true that that absent that, it's, you know, et cetera, et cetera, et cetera. So even arguably that if there's a vouching problem here, isn't it fully cured by opportunity to cross-examine?
I don't think so, because it's an expert opinion. The expert, there's a.
Yeah, but the cross-examination says you're not an expert in the science of credibility. Yeah, you know, you haven't done MMPI tests and so forth and so on. Are you a mind reader, doctor? You are just assuming the credibility of the statement. You know, I'm working up across and.
Right, and I think they did cross-examine this doctor on that. I think the Court of Appeals addressed that when an expert testifies, such as a case like this, it's misleading the jury into thinking that he knows something more than they do.
Cross-examination, he admits. I'm looking at Supplemental Appendix 64. Without the witness statements, I could not have diagnosed drowning in this case. What more do you need?
Well, I think that it's inadmissible before that because of the vouching problem, because it's an expert witness vouching for, and it's really, as the Court of Appeals says, not even expert medical opinion.
But is it vouching any time an expert incorporates facts or statements or I mean, experts incorporate facts and statements and data into their opinions all the time.
And I'm not suggesting that that's wrong. The issue here, I think, is a very narrow one. It's not a broad assertion that experts or medical examiners cannot take into account other things. In this case, it's the only thing we have.
Before we get off this subject, before you start answering the questions down from this side, you said there's a code provision that prohibits the examiner from using the statement. Did I hear you right?
Iowa Code Section 331.802, subsection 6, states that the autopsy report shall be received into evidence except statements by the witnesses or others are not admissible. And I take that to mean that those statements in a coroner's inquiry or medical examiner's investigation cannot be included in the report. And I think similarly, the statements have to be otherwise admissible under the rules of evidence and under our jurisprudence of expert testimony, and our position is because this is the only thing. The Rollins court case mentioned by the state, in that case, the medical examiner testified that without the witness statements, he would still come to the same conclusion. So there were other indicators in that case.
I have trouble accepting your premise that this is the only thing, because maybe it's what put it over the top, but he had all those other things.
He had a dead baby, and he had a baby that could have been stillborn. He testified he had a baby that could have died of SIDS, that could have died by a condition called RH factor, could have died by a lot of other causes. So there was not even that much evidence the baby was ever alive. So yeah, there was no way that this doctor was going to come to the conclusion of a homicide or drowning without the statements of the defendant.
But he had objective reasons to rule out a number of other causes, right?
Yeah, he did rule out, like for instance, there was no toxicology.
So doesn't just the leap he's making, which he's upfront about, it took the confession to get him to his ultimate conclusion. Isn't that just something that goes to the weight of his opinion rather than its admissibility?
I think if it weren't for the fact that it was relying on statements, if it was relying on, is this consistent with a drowning or something like that, not mentioning what or not relying on what she said.
Was the confession admitted into evidence?
Yes.
So is your position that an expert should be precluded from considering a confession that's already the jury's hearing?
Yes. Because it's expert testimony and the likelihood of the jury substituting an expert state agency and, for their own opinion is very high. And also, I think the other problem that we have, particularly with confessions, that's separate from just witness statements or police investigations that are discussed in a lot of the cases, is that are we going to ask medical examiners to become an expert on false confessions? And how is the medical examiner, because that was another issue at trial, was that they alleged that the confession was coerced. And
if I were a medical doctor sitting here listening to this argument, I think I would be thinking, now wait a minute, when I'm going through this medical procedure, I'm not vouching for anyone, I'm not commenting on anyone's credibility. I am following a protocol that we find to be scientifically correct, and why shouldn't courts accept what the scientific community accepts when they go through their analysis to reach their scientific conclusions?
In this case, because the medical examiner's opinion and conclusions were not based in science, they were based on her confession and the veracity of that confession.
Well, as Justice Mansfield said, that it's based upon everything that's before the doctor, including his training or her training and education, experience, everything that they've done, they're putting into this analysis, which includes the background information and facts that bring the opinion before the attention of the doctor, just like any other expert in any other case. They have to know what happened. They have to have some background information. And isn't that just part of a greater issue that doctors and other experts resolve when they do their work?
In this case, because it's similar to what the Court of Appeals cited in the Vining case, which is, the medical examiner's findings were inconclusive until convinced by the police investigation, until convinced by the defendant. We're not suggesting that the autopsy itself report, that the medical examiner cannot testify about the findings of the autopsy report. It's the conclusions, because it's not a medical conclusion. It's not an expert medical conclusion of homicide and drowning. That's
what if the doctor begins, the first thing the doctor considers is the statement of the defendant. And then beginning with that, then he goes through all of these scientific processes and trying to rule in things. And then after he goes through all of this analysis, then he comes to his conclusion. Is that conclusion resting solely on the statement of the defendant?
These are very fact specific, so I think that's a little too general for me to answer specifically. Each of the cases from the other states that both sides have discussed, it depends very much on what the information is.
Take the other side of the coin here. What if you called an expert to show that her confession was false by saying that I've done all my medical stuff and there's no way this kid could have drowned, so it's my opinion the kid didn't drown? Are you allowed to do that?
Based on the medical evidence? Yes.
Are you allowed to ask the witness the ultimate question, and this is the bothersome part, that in my opinion the kid did not drown? If you're going to ask that, then why can't the state ask the other one? Why can't the state expert say the other thing?
I think I keep going back to it's the vouching for the credibility of the statements. We're not saying that the scientific information is not admissible or even verifiable facts or data, what have you, from the scene. It's the fact that this was only based on.
We have cases in the civil area where an expert cannot testify that, say, a product's defectively dangerous, but an expert can testify all the engineering factors that make it defectively dangerous because it's the jury's decision. So it seems what we're saying here, or what you're saying here, is that you can put all the evidence in, but it's really not, it's more than vouching for the credibility. It's actually answering the ultimate question the jury has to decide. And that may be, because of the way it's phrased, at least in a beyond the reasonable doubt case.
And in this case, I think that, yeah, I mean, even the Court of Appeals pretty much went that far to say not only is it vouching for the credibility, but substituting the expert's opinion.
Let me ask this question, hypothetical. Supposing the expert testifies on all the science that I think we all recognize comes in, and then at the very end, the question that's posed is, I want to ask you a hypothetical question. Suppose, hypothetically, the mother stated that death was by drowning. Now, based on that hypothetical, can you render an opinion? Now, if that's the presentation,
I think that's a closer
there's no
question,
vouching.
and I think that maybe something more consistent with drowning. It's, you know, if this set of facts is consistent with this result, is a closer question, because it's not vouching for the credibility of the only, you know, it's not based entirely on, you know, statements of the witness.
It's not based at all on statement of witness, the way my hypothetical is.
Right.
I mean, and I'm trying to screen out the credibility questions, and I have no idea what the expert's answer would have been. But if the expert would have been unable to go on and give an opinion, that would be interesting too, I think. But
I don't know the answer to that question. I see my time is up. Thank you very much.
Thank you as well, Ms. Ruhtenberg. Mr. Buller, you may present your rebuttal.
I want to start off by...
Before you start, I'm not going to let you start. I want to ask you, Mike, the same question I asked her. What if the defendant hired an expert who said, based on my opinion, there's no possibility this child drowned, thus it's a false confession? Can they do that?
Believe it or not, that is where I was going to start. I think you are fine with that statement until you get to the false confession part. We could have had a defense expert that was asked exactly the same questions Dr. Thompson was, and that would have been admissible.
But by asking that last question, she drowned, you're saying it's not a false confession. You see, that's the line that's getting crossed there, because if it's good for the goose, it has to be good for the gander. And if you can ask that question, then these defendants should be able to hire experts and say it is impossible for that kid to drown, and you've just said it's a false confession.
If the testimony stops with, in my opinion, to a reasonable degree of medical certainty, it was impossible for the child to drown, that's admissible in Iowa. This court has said time and time again that we take a liberal approach to the admissibility of expert testimony. We trust that Iowa jurors are smart enough to know.
Isn't that saying the confession's false? I mean, we could play these word games, you know, how far you go, but isn't the essence of that testimony the confession's false?
No, Your Honor, no more than every other piece of evidence offered by either the state or the defendant supports one particular version of events. In some very broad, abstract sense, everything everybody offers in a trial is bolstering evidence. The state's not going to put on evidence that disproves its case, and the defense is going to offer evidence that supports its version of events. The line we're talking about is when an expert says...
I hope that the state would put on evidence that's fair and not just try to convict somebody, but something that's fair and it may or may not prove their case. I hope you're not espousing that for you.
Well, certainly not, Your Honor, but I think we can expect that as advocates, evidence offered by a party supports their version of events. I don't think that's a controversial proposition. That's why this floating concept of an indirect comment on credibility is so problematic, because everything's an indirect comment on credibility. We don't have any direct comments here, and that should end our analysis. Dr. Thompson didn't say he believed the defendant, that she was credible, or that he thought she was telling the truth.
What about the other prong of this that I look at, I guess, which is invading the province of the jury, reaching the ultimate conclusion? I guess I want you to respond to that a little bit, because when you say the cause of death is bathtub drowning, it's pretty darn specific. And then when, even on cross-examination, you have to get out the fact that, well, no, I can't really say or prove or that it was a bathtub drowning, because the only thing I can do is rely upon what she said. And of course, in this case, the ultimate question is, was the child even alive at birth? And this, to me, I just want you to respond, I guess, to those, because it's not only the bathtub drowning, but then it's the use of the word homicide. And I think the doctor did a great job of explaining. We have these 5 different manners of death that we typically rely upon. But even under this set of facts, it does seem to be undetermined, because that's what we're asking the jury to do in this case, is to determine whether the child was alive or dead at the time of
And Your Honor, I would say that's not all we're asking the jury to do. The invading the province of the jury, the ultimate question in doctrine in Iowa, is very narrow. It's opinions as to guilt or innocence. Testifying that it's a homicide, or even the mechanism of a homicide, is not testimony that the defendant is guilty. The fact that a homicide took place never means that the defendant is the one who perpetrated the crime. That, I think, answers your...
I think our law is broader than that, a guilt and innocent, because if you read Allers versus Roger, machinery manufacturing, you cannot testify as to an ultimate fact question to be determined by the jury. And in this case, the ultimate fact question was the baby drowned, or was the baby born dead? That is an ultimate fact question in this case.
But there's no question that an expert can offer an opinion as to the most medically likely cause of death, even if that's one of the elements under 707.1 and 707.3. I would end with pointing out that if you read the case law in other jurisdictions, the overwhelming rule is that medical examiners may rely on witness statements. That's the law in South Carolina, New York, Kentucky, Utah, Georgia, and Minnesota.
Yeah, and I don't think that anybody's necessarily arguing that they can't rely on them. I don't think, certainly, I think the defense is arguing that we ought to have them not be able to look at them at all, and I'm certainly not there. I think it's clear that they're going to be able to look at that type of information, but and I guess my question was there any redaction of the medical examiner's report at the time of trial, or is Exhibit 50 the one that was admitted at the time of trial, if you know?
The only version we have is the version that was offered at trial, so I don't have anything to compare that to, Your Honor.
Sorry.
Thank you, Mr. Bowler.
Thank you.
State versus Tyler is then submitted, and the bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.